SJC-12857, Mark Mendes v. Fidelity and Guarantee Insurance Company, and others.
Do we have Mr. Sahadi?
Your Honors, Attorney Sahadi indicated approximately 10 minutes of 9. He had learned that this argument is going to be taking place at 10.
No.
He went to get a cup of coffee.
Okay.
I'm sure the court, there's no such communication.
I think so, Mr. Keneally.
Okay, do we have anybody, I guess we're taking our
Who's this?
morning break.
Is that Mr. Sahadi?
Oh, wait,
Hot
who's
coffee.
this?
Yes,
There you go.
the officer advised me it was approximately 10:30 that it would start. I apologize.
Okay,
Can't believe anybody.
gather yourself, and we can commence. And you can thank your brother for telling us what happened later, so.
I sincerely apologize, Your Honor.
That's all right, that's all right, that's all right. Okay, you ready?
Catch your breath.
As ready as I'll ever be.
Okay, well then, we'll start.
Good morning, Your Honors.
Why don't you approach the microphone so that you can both be heard by us and also be
The
heard
rest
by
of the
the
world on camera.
camera.
Good morning, Your Honors, Chief Justice, Justices. My name is John Sahadi. I represent the appellant, Mark Mendes. May it please the court. I may refer to him more as the employee than the appellant, given that this is a workers' compensation matter. And we are accustomed to referring to the party as the employee and the opposing party as the insurer or the employer. The court today has a great opportunity to clarify and to set forth a standard for establishing jurisdiction over certain workers' compensation matters in Massachusetts.
Is that a good idea in a case involving trucking?
I'm sorry, Your Honor?
Is that a good idea in a case involving trucking?
Is establishing jurisdiction a good idea?
Resolving this issue. I mean, we've got the contract from Pennsylvania, we've got all the cases dealing with trucking, we've got Larson telling us about this is a very unusual situation. I mean, is this the right case for what you just said?
I would say it's perhaps one of the rightest cases. Larson describes the state of the law in various jurisdictions. Larson isn't the authority on the law, as this court is. Larson, if you read between the lines, makes an effort to try not to push in any particular direction. But if we were to infer an opinion from Larson's latest treatise, it would be that something closer to the New York approach would make more sense than the artificial edifice created by the transference of the contract from one state to another. Because as the state of the law in Massachusetts is, we have established that we recognize 3 independent tests for jurisdiction: place of hire, place of injury, and localization of employment. Not primary localization, not principal localization. The language used in our courts has been localization and place of employment relations. And the reason that principal localization ought not be the determining factor is that, and Larson clearly states, that we ought not have a weighing of the interests of one jurisdiction over another, or the substantive contacts in one jurisdiction being greater than those of another. The reason for that is that, first, we have clearly established that we may have concurrent jurisdiction in multiple states as long as there is no double recovery and there's an offset. Secondly, as Alaska Packers clearly stated, the legitimate interests of one state cannot supersede the legitimate interests of another state. The jurisdiction of this Commonwealth, subject matter jurisdiction, cannot be stripped away simply because another state has its own substantive legitimate interests. We have great interest in protecting workers in the position that this employee is in. He is currently a charge of the state. He is receiving Social Security disability benefits, which come out of our pockets as taxpayers, and he is on Mass Health, which also is funded by us as taxpayers.
So you'd say those cases like Patton case from the Illinois situation is just distinguishable based on primary localization of employment as opposed to localization of employment?
I think what the appellees have attempted to do is create an artificial analysis whereby mileage is the focus. And because he drove more miles in Pennsylvania than any other state, and because his original contract of hire was in Pennsylvania, he thereby is relegated to the jurisdiction of Pennsylvania, which is a shit.
I think it was more than that, though, wasn't it, that he really just comes back to Massachusetts for the weekends?
If in
And
fact,
pays his own mileage and...
that's actually incorrect, Your Honor. If in fact that is what they are alleging, and if we read their brief, I don't think we'd ever know that he made very many deliveries in Massachusetts, that he went from place to place to place in Massachusetts, picking up full loads, being the first driver to touch them, prepared for him in Massachusetts at 3 terminals, Weymouth, Bonneville, and Leominster. And at each of those 3 terminals, there were 20 to 40 trailers belonging to the employer in this case. They obtained use of those terminals gratis from their customers in Massachusetts out of sheer goodwill, which shows the extent of the business that this employer has in Massachusetts. And if we look at the...
Do we know, I'm just, and I haven't broken down all these miles, I'm not sure it's all in the record, but you say he's driven more miles in Pennsylvania than in Massachusetts. Do we have the comparables on that? I'm just curious.
There is a chart
Okay.
that was compiled by the witness for the employer.
So Justice Budd has helped me out here and said, so there's 28% in Pennsylvania and about 12% in Massachusetts.
Massachusetts was the second most in terms of mileage. But I'd like to make an analogy. If I drove to California, took a great look at the majestic Pacific Ocean, and drove back without doing anything else, I would have racked up a lot of miles. But if I drove 200 miles back and forth across Massachusetts and made 100 pickups and deliveries in that process, which is more significant, the mileage or the work activity?
I understand we shouldn't look at pure mileage, but do we have a sense of how many times he was sort of doing like a Massachusetts run?
We do, Your Honor.
And do we know the percentage of, because it seems like in some ways he is localized to Massachusetts.
Very much so.
Right, but do we have a sense of how many sort of Massachusetts trips as opposed to Pennsylvania trips he's done?
We do, Your Honor.
And what is that answer?
In my brief, and more importantly, in Judge Braithwaite's findings, he made, I believe, 16 or 18 specific findings. Coming home for the weekend is only one of them. I think the Massachusetts appears in this, what is called the Smith Transport, Inc. Driver Movement Report. It is probably the most important exhibit in the case, and it is self-explanatory with the exception of a few lines, which I would hope to have the opportunity to explain a little bit. And it shows every time Massachusetts is the state of the trip origin, the load city, the destination city, and the deadhead city, meaning his tractor was without a trailer. Not only does Massachusetts appear 150 times as one of those major trip events, but even when he was going home to New Bedford for 1 day a week, he was paid for those miles to travel home. His tractor trailer was insured. Its contents were insured when he parked in New Bedford. His tractor trailer was in the Commonwealth on more individual days in that year that he worked than in any other state.
If I can step you back, so excuse my ignorance on workers' comp matters, but I'm trying to get some sense as to what the context of this is. So he's injured in Maine.
Yes, Your Honor.
He seeks workers' comp, and does the insurance company pay him?
There was I believe, a pay without prejudice period. And then there was an initial temporary without prejudice conference order. And then it went to hearing. Judge Sullivan, the original hearing judge, and the hearing is more like a trial, found that he was totally disabled from the time of injury to the time of the decision and continuing. This was many years ago.
Right.
And he found, however, without explanation, that the Carlin and Hillman cases did not apply.
This is all focused on the issue of jurisdiction, but what does that mean in practice?
He found there was no jurisdiction.
Meaning that the dispute between the insurer and Mr. Mendes cannot be resolved in a Massachusetts court?
Meaning that Massachusetts did not have jurisdiction over his claim, and we appealed.
So did not have meaning that, I mean, this is not a Massachusetts insurer, so.
They do write they do have workers'
So
compensation.
is the issue who pays? Is it going to be a Massachusetts insurer as opposed to, say, a Pennsylvania insurer? Is it an issue of in which court can adjudicate the dispute? I'm just trying to sort out what really is at issue here.
At issue here is the very basic question of whether Massachusetts has subject matter jurisdiction over his workers' compensation claim.
And he could file a workers' compensation claim in Pennsylvania.
Probably not now, given that the statute of limitations would have expired, but even more important, and this is quite prolific in the dicta and in the rulings of previous cases, the public policy against having a disabled worker who is without means to travel great distances to a foreign jurisdiction when his contacts in Massachusetts were significant and substantial, his work contacts, is against public policy.
But just practically speaking, if he did go to, if it was adjudicated in Pennsylvania, what would he have to travel to do an exam or something like that, or?
He would have to go through their system. He would have to travel there. He would have to litigate there. He'd have to have a lawyer there. He probably would have to be examined. I don't know what because every state has a different system. Not all of them are administrative. Some go straight to court. In fact, in this case, there was a scheme originally whereby no one could be hired unless they signed a forum selection clause that stated that if you are injured at work and you bring up workers' compensation claim, it is to be brought under the laws of the state of Indiana.
Meaning that is to be the choice of law.
Yes, except that no other system would actually litigate under the laws of Indiana. He would have to go to Indiana to make that claim. And in fact,
That's
Indiana,
not true. I mean, Massachusetts can resolve cases under the law of Indiana.
in a regular court, yes, Your Honor, but in an administrative system, I don't believe I've ever seen a case where the Department of Industrial Accidents.
So is the issue then as to whether or not the administrative tribunal has jurisdiction? So this is not a long-arm jurisdiction issue, because a court certainly would. I mean, a court, if basically he said, I've got a dispute involving an injury that occurred in Maine, but I'm a Massachusetts resident and I'm seeking to have another insurer pay for me, I can bring that case in Massachusetts for sure under the long-arm jurisdiction.
Absolutely, Your Honor.
So the question is whether or not we should apply a different law a different jurisdictional rule with regard to workers' comp?
No, in fact, my argument and the argument of the amici.
Are you talking around each other, though? Because the chief's focusing on court jurisdiction, but you're focusing on which Department of Industrial Accident will resolve the issue, which law it will apply. Because, I mean, again, I'm not that familiar with that concept in this area, but I don't think Departments of Industrial Accidents in Indiana are applying Massachusetts DIA law, workers' comp law. What it is this is a one-stop issue. All of those issues are decided down below by which jurisdiction you're selecting, right? I mean, I just want to make sure you two are talking on the same issue.
I don't believe that any administrative agency in the country would accept litigation according to the laws of another state.
At the Department of Industrial Accident level, you mean?
Yes.
Because we do, once you get to our level, we do this all the time. We have a whole choice of law thing. You're talking about which Department of Industrial Accident will assert jurisdiction over it, and it will apply its own laws to that. It will not do this kind of mongrel that we do in court, right?
I'm actually suggesting that the Chief Justice's proposition be adopted. Okay. That the test for jurisdiction, it's not just the department's jurisdiction, it's the Commonwealth's jurisdiction. Ultimately, this court is the final arbiter of what the statute means, if there is a hold,
So that's the other question I have. Are we interpreting the workers' comp statute, which appears to be relatively silent on the issue of this, except to the extent that it says that whether within or without the Commonwealth, he shall be paid compensation? Well, is that all we have to work with?
It is not, Your Honor. First, we have Conant's case, which is an appeals court case, which has been around for a while, unchallenged, and represents the state of the law, which instructs us that the act is a humanitarian measure designed to provide for victims of industrial accidents and to prevent the injured worker from becoming a public charge to the taxpayers of the Commonwealth.
Which I guess he is right now.
He is, absolutely, and has been for quite some time. Secondly, the second purpose is, the second principle is that because there are such great public policy concerns as a humanitarian measure and so as to prevent him from becoming a public charge, we are to view jurisdiction over workers' compensation cases liberally and broadly. It is not a restrictive analysis. It is to be expanded as much as possible. Then we have two cases from the reviewing board itself, the Carlin case and the Hillman case. Hillman is more on point and is more recent. And in Hillman, the employee lived in New York, originally started in Massachusetts, then was involuntarily transferred to New York, where he worked for 10 years, dispatched out of New York, did his runs out of New York.
I'm sorry, I just want to refocus back on the practical, because we understand you're saying that Massachusetts is where it's a broad jurisdiction and Massachusetts should be the place that this all happens. It sounds like you're saying that if not here, it's not going to happen at all. He will not, and he hasn't gotten any kind of workers' comp benefits at all because it's not happening here in Massachusetts.
He would be unable to travel, and
And you're saying he would have to travel. There'd be no other way to do it.
that's correct, Your Honor. And in fact, we did have a claim filed many years ago in Indiana as a prophylactic measure, but even that, the unenforceable contract that he signed to have Indiana as the forum state would fail because Indiana itself does not have jurisdiction based on localization. He never worked in Indiana.
Okay, what about Pennsylvania, though?
Pennsylvania would be beyond his reach at this point.
I understand beyond this point, but I'm just trying to figure out.
It could be, yes, but there is concurrent jurisdiction. There could be.
I understand. No, I understand. Massachusetts is the best place as far as you're concerned.
Yes, Your Honor. He would.
And it makes sense.
Pennsylvania would have jurisdiction, yes. I
What about
do
Maine?
concede that.
Would Maine have jurisdiction? He was injured in Maine, wasn't he?
As the place of injury, I would say if their statute allows for that, yes.
Okay.
Where did the employer pay any employment workers' compensation taxes?
Workers' compensation taxes. I'm not sure that issue never arose, Your Honor, but they do have an active policy through Fidelity Insurance and Guarantee in Massachusetts.
So are we deciding not only which DIA decides this matter, but also which insurer is to pay?
No, Your Honor, there's only one insurer.
Only one insurer. So
Correct.
the same insurer is going to pay regardless of where.
I don't know if they had a different insurer in different states. I know in Massachusetts, they do have a policy underwritten by Fidelity
Okay,
Insurance
so
and
it's
Guarantee.
conceivable that if it's in Pennsylvania, there would be a workers' comp policy in Pennsylvania, which may be hit.
That was never at issue in this case. I tried to bring in the strategies they were employing in other states, and the hearing judges would always tell me that's not relevant. We're focusing on
Isn't
Massachusetts.
that, I thought they only have one workers' comp. Each company will have one workers' comp insurer. They're not going to have a different workers' comp insurer per state.
Perhaps my brother would be able to answer that question. I do know this is a conglomerate of trucking companies. They may be partially self-insured with an umbrella policy through Fidelity. I'm not exactly sure as to how that works. But what I am sure of is that the contacts that this employee had with Massachusetts, the constellation of facts that support those contacts, are a magnitude of order greater than any other case in which the theory of localization or place of employment relations has applied. We have recognized in Massachusetts that there are 3 independent tests for jurisdiction over workers' compensation matters: place of injury, place of hire, and theory of localization. That theory does have to be fleshed out.
Okay.
And the amici, to whom I'm extremely grateful, are making great suggestions in their brief. They're practical, they're a guide, and it suggests that it be analyzed on a case-by-case basis, given the facts of each case, such that the judge would have discretion to broadly and liberally interpret the statute so as to fulfill its meaning, its intent.
Okay, thank you, Mr. Newmeyer.
Thank you, Your Honors.
Help us to understand what is at stake here.
Morning, Your Honors. My name is Richard Newmeyer. With me is Jack White. I want to begin by saying this isn't my first worker compensation argument. That occurred in the opinion appears in Volume 3 of the Appeals Court. Back then, some may regard it as the beginning of time, there were 2 bases for jurisdiction: the place of the contract and the place of the injury. You can file it in either one.
Place
Either
of
state.
injury, is that what you said?
Excuse me?
Place of injury, is that what you said?
Place of injury, yes.
So that would mean here, it would be Pennsylvania or
Place of injury was Maine.
Maine, right?
The contract is in Pennsylvania. Since then, since the first case I argued, other states, and in Massachusetts, the lower courts and the Department of Industrial Excellence, and Larson's treatise, and the National Commission on State Workmen's Compensation Laws, which I encourage you to follow, because those folks have really thought a lot about it, have said there could be another basis, localization.
Before you go
Sometimes
into
called
all
principal
that stuff,
lexicon.
can we please just understand what the stakes are? Because I think we're trying to understand why this is a big deal.
Well, it is a big deal to have the doctrine of localization articulated in a consistent fashion. That's a big deal.
Okay, but in terms of what it means for your client, I understand we want to consistently apply the rules, and that makes sense, and we're absolutely going to figure that out.
Right.
But we just want to understand why you guys are fighting about it.
Okay. It's important to have the law consistent in dealing with the same areas,
What will it mean
frankly.
for your client?
I'm not sure what that, I'm not sure I understand
Is
that.
it money?
Client hire you.
This is a matter of high principle in the transportation industry, I am told. And in the transportation industry, we have a lot of people, truck drivers, flight attendants, pilots, who are all over the place. This trucker, in 12 months, drove in 25 states. He drove 112,000 miles, 13,000 approximately in Massachusetts, 20-something in Pennsylvania. So where is he doing business? Where is a flight attendant doing business? Where is a baseball umpire doing business? What state is it doing business? The answer to that is, who knows, really? I mean, let me take Tom Brady.
But it's
2019, he-
Just one second. I
Yes.
think it's important, right? It's a practical matter. It affects how much the benefits are, right? Some states are much more generous than other states, and the employee has the incentive to being in the most generous state, and the employer has the one being in the least generous state a lot of the time, right?
Well, I suppose that's true. I don't know. Sometimes states change their laws. So you enter into an employment contract and the thing changes around. That can happen too.
Yeah, and that goes back to Justice Budd's question, right? What are the stakes of this case?
If we're talking about dollars, I don't believe the answer to that question is in the record. And
Let me try it this way.
yeah, sure.
Is your client paying if it's in Pennsylvania?
I don't think the answer to that question is in the record, and I don't know Pennsylvania law. I do know that under Massachusetts law and the other 49 states we have in the United States, we have legal malpractice claims. I've defended a lot of those claims. And if a lawyer files a claim in the wrong state or doesn't make the statute of limitations, that could be a problem. It's a hypothetical problem here.
I
but
guess,
I
I guess,
think-
I guess
I
more broadly, I guess the question, if in a world without workers' comp, and he sued his employer for injuries that he sustained outside of Massachusetts, we would say he has jurisdiction here to bring that suit in a court of law.
Well, in a personal injury case, I suppose that's
Certainly, there would be enough contacts with Massachusetts here to permit him to bring a claim in Massachusetts claiming personal injury.
right. But this is not a tort case. This is a worker
Right,
compensation.
and I guess the question is, why should we be less protective of Massachusetts employees because there's workers' comp than we would be without?
Because Massachusetts should not say, we're going to have a theory of localization which nobody else in the United States follows, which is not followed by Larson's, which is not followed by the National Commissions on State Workmen's Compensation Laws, unless you've really got a really good reason to disagree with Larson and the National Commission.
Your theory, which state should he have applied in?
Well,
Where would he have gotten, where would the court have said, or the DIA equivalent have said, no problem, we see you're covered?
he's clearly covered in Maine, and he's clearly covered in Pennsylvania. And my brother says, whenever you make a worker compensation claim, you've got to go there. That's only the case in contested cases. Most worker compensation claims are not contested. If there's an accident, there's disability, there's medical bills, it doesn't make any sense for the insurer to hire a lawyer to contest that and have a hearing about that. That is not a productive use of the insurer's money. So I just want to make that observation.
Going back to the chief's question, though, It's even more complicated, right? Because in the tort law, we may assert jurisdiction, but then we may use our conflict laws to apply the law of another state. The Department of Industrial Accidents never do that, right? It's all decided in one
That's
ball of
correct.
wax.
They decide whether they have jurisdiction, and if they have jurisdiction, they apply Massachusetts law. And every other state does that.
And that's the law. When we read Larson and these other treatises, it's a one-step determination. You're going to find out, because a lot of these are sort of quick, you know, it's not tort cases. It's a very quick decision, often accepting liability.
You are 100% correct.
So, but let's go back then, because there is, when we look at all those treatises that you're telling us, there's a theory of localization, but it seems like the DIA, at least the administrative board, required a transfer step in localization. That's where I have, right? Didn't they do that here?
They did that
And is
because that's what the law is in almost every other jurisdiction. That's the overwhelming majority rule. Sorry.
And I know you know this stuff well, but isn't that somewhat problematic in this case, which it looks like he's almost localized from the get-go, in the sense that, and bear with me because I understand.
Sure.
I'm just trying to refine the test a little bit and why we should always apply a transfer theory when it looks like this guy, they sort of cut a deal with him where he could do a lot of his work out of Massachusetts, and then we're stuck footing the bill for a lot of his health problems. Why shouldn't we modify our that transfer step?
Your Honor, you have identified the employee's central argument in this case, which is based on the employer's policy of permitting its employees, to the extent possible, to go home on the weekend and be with their family.
But more than that, he's also serving the employer's interest, which is, the employer does a lot of business out of these 3 terminals in Massachusetts, doesn't he? And he's helping the employer by having this guy pick up loads in Mass too, doesn't he?
Well, this is where we have a slight disagreement, Your Honor. From my perspective, the guy's job is to drive the truck. That's what he principally does. I recognize that he picks stuff up and he drops stuff off, and sometimes he unloads stuff. But basically, he's transporting stuff from one place to another. So in terms of figuring out what he's doing, I think it makes sense to look at the 112,000 miles and where he traveled. So we do have a difference of opinion on that.
But I get
because
that.
he's also making pickups, which my brother has not mentioned it, in many other states. But the company's policy is to permit its drivers, to the extent possible, to go home to their family on the weekend. And he drives deadhead miles, as they're called. To say that that is a basis for localization is bad public policy.
Why?
Because it discourages employers from granting opportunities for their employees to be home with their families. And if anything we want to do, anything this court wants to do, we want to encourage that kind of activity.
But wouldn't we encourage it by having the workers' comp follow? If they're that generous, say you've got this kind-hearted employer you're describing. He wants his employee to be able to go home for the weekends.
Sure.
That person lives in Massachusetts. When he gets hurt, he's going to be on our health care if he's not provided health care. He's going to be a ward of our state, and he's doing a lot of business out of Massachusetts, too. Why isn't that enough to meet this localization test?
Well, I ask you to think about that for some time, just a few minutes.
Okay.
If every state is going to do this, that means that in addition to the contract to hire, the place of injury, existing localization, we're going to have where the employee lives. So does that mean if the employee starts out in Massachusetts and chooses to move to Rhode Island, some people have done that, that then the employee can say, I was injured in Maine, but I'm not going to file a claim up
Well,
there. I want to get paid in Rhode
I look at it a little
Island.
differently. So, okay, so my law clerk is, he's gone to go become a law professor, and he can't, his wife lives in one state and he lives in the other.
Yeah.
But he's still, all his work is in that other state, just because he lives here. But this guy's different. He's actually helping the employer by being in Massachusetts, because he can pick up a bunch of loads here.
Well, the impression that the only loads being picked up are in Massachusetts
Not saying the only ones.
is incorrect. I mean, he's only spending, 13% of his time or something like that, 12, in Massachusetts. He's picking up a lot more loads elsewhere. I mean, I don't have it, but it's somewhere in the paperwork as to how many loads he picks up in Pennsylvania, which is where he spent, most of his time. And the other 25 states, he's picking up loads and delivering them there too.
Well, does he end
So-
up in
so-
Pennsylvania, because they need the thing delivered to Pennsylvania in the end of the day, right? A lot of the time.
The trips go all over the place. And sometimes the trips are, he'll deliver it halfway there, and another trucker will pick it up and deliver it the rest of the way. And so there's all kinds of compensations. But the cases, the great majority of cases say that localization only applies, or principal localization as it's more frequently used, when there's something happened that changes the employment relationship. And in this case, it is uncontested that nothing happened in the 12 months to change the employment relationship. Now, in the patent case, the guy lived in Illinois, he was hired in Missouri, and he was injured in Indiana. He only had 1.5% of his time of his trips in Missouri, which is where he was hired. Only 1.5%. 48% of his time was in Illinois. And the court said that's not a basis for localization in Illinois because nothing changed after you were hired.
What do you say is the practical consequence of the agreement which says choice of law is Indiana?
Well, that was ruled out, and we haven't contested that. When the first reviewing board decision said that, we said, okay, fine,
So you're saying that was essentially void?
It's
Public policy?
yes.
It goes to the issue of how lovely your employer might be, since I guess Indiana may not be the most generous of states.
Well, I don't know. I don't know what the benefits are in Indiana, to be perfectly
So you say
candid.
that
But I
basically
do
is
know.
irrelevant to
I do know that the insurer did not want to pay to litigate that question. That I can tell you. That's the thing I know for certainty. So we're here on the important question, which is localization. And I would just ask that you consider the problem created by Massachusetts saying we're going to do something that,
Could you just explain to me what it is that localization means? What are the criteria that you think are correctly applied? What should we be doing that we're not doing?
well, I would rely upon Larson, frankly,
Well,
who's
and
thought about,
who says what?
who
Tell me
says
what.
that something has to change in the employment relationship. And sometimes it's a new contract of hire, but usually it's an assignment to say you're hired in one state and then you move to another state and you spend all this time working in this other state and then you have an injury or a death.
But
There are
does
a lot
that-
of cases like
Does
that.
that make sense in a, given the consolidation of industry and everything else, just where you get hired, where corporate headquarters is?
Well, the contract of hire has been around, I think, since the beginning of Chapter 152 and the
No, I
beginning
get
of
it,
workers'
but we're
compensation.
living in a new world too, from that time period where contract of hire was basically the equivalent of where you were working.
Well, we are living in a new world. We still have contracts of hire, and we still have statutes that have not changed what the contract of hire or the place of injury is. And of course, this court has got to go by what the statute says. I see that my time is up. But
I guess I have one more question before you sit down. I understand why it matters that we be clear. because employees need to know where to go, and we don't want there to be ambiguity. But why is it so important that we not say that if the employee resides in Massachusetts and if the person does a substantial amount of work in Massachusetts, that suffices for jurisdiction?
I think that creates an enormous problem of trying to figure out what the law is. I mean, does that mean that any resident of Massachusetts can go to a worker compensation lawyer in Massachusetts and say, well, I can file here because the SJC is going to say you're going to collect here, even though the contract was in another state and the injury was in a third state?
You'd have to show that you did a substantial amount of work in Massachusetts.
Well, what's the test for that to be? Here, they're saying 13% of the driving, or 12%, whatever it is, plus permitting the employee to go home on the weekends. That's substantial. Well, if that's substantial, you know, there's all kinds of places that would be where worker compensation claims could be filed. And I do think that's not a good idea. We already have state of hire, place of injury, localization of principal localization. If we're going to tack on what would be a fourth thing, which is, well, you're here, and we're afraid of you going on welfare, then you can file it anywhere, you know, and that doesn't make good policy, good sense. Thank you.
Okay, thank you.